Webinar in BDO's Education Sector webinar series for 2018. It's my pleasure to present today's webinar on the very important topic of the Notifiable Data Breach Scheme, which is contained in the Privacy Act, which, as you most likely know, commenced on the 22nd of February of this year. If you look at the many surveys conducted in all sectors of the economy about the issues concerning sector leaders, you will find that data protection and cybersecurity among the top 5 issues of concern. This is no less the case for the education sector. My presentation today will provide you with background information about various aspects of this topic, with information concerning the NDB scheme, and I'll finish up with some practical handy hints. So why do we care about this topic? Well, there are a number of reasons, and my next few slides will take you through some of them. Entities, and I have used the word entities rather than agencies and organisations, which are the language used in the Privacy Act, but I've used entities to encompass a much broader audience than the entities that may be covered by the Privacy Act. So entities hold increasingly larger amounts of personal information in electronic form, making us all vulnerable to misuse of that information. Identity theft, identity fraud, stalking, online bullying, blackmail are some of the consequences of this new world that we live in. Entities may suffer reputational damage and economic loss as a result of a data breach, and we've seen many examples of this in recent times. Entities need clear directions and guidelines as to what they need to do when there is a data breach. Prior to legislative intervention, what we had is really entity by entity making decisions as to what they would do, when they would do it, how they would do it, if there was a data breach. And I think that's very much an ad hoc approach to a very complex problem. We need to have confidence that entities prioritise the privacy of personal information. One can argue that that certainly isn't the case at the moment. And we need more comprehensive information about data breaches so that they will better inform policymakers, our regulators, law enforcement, and researchers about developments in the field. So data breaches, I'm sure you all have a good handle on what data breaches look like, but I thought I would list a few just to remind us all, and I've called it from negligent to nefarious. So here are some examples: lost or stolen laptops, removable storage devices, particularly the USB, or paper records containing personal information. We've all heard stories about how people leave their laptops, their mobiles, in the backs of taxis, on trains, in planes, and paper records not being disposed of in a secure manner. Then we have the problem with hard disk drives and other digital storage media being disposed of or returned to equipment lessors without the contents first being erased. People forget that just because you push delete on a message or a document doesn't mean that it is completely deleted from the device on which the document has been created. And of course, you have a similar problem with computers and other paraphernalia that you own. If you want to upgrade, again, people say, well, I'll go and buy a new device and I'll just throw the old one away, forgetting that there's lots of personal information that might be stored on the old device. Then, of course, we have the problem of hacking or illegal access to databases. And for those of you who are not familiar with the acronym BYOD, it means bring your own device. Why is that a problem? Well, if you have a laptop or other platform and you are using it in connection with an organization's network, but it's not properly patched in and secured, then hackers, using their ingenuity, can come in through your device, which isn't secure, and then access the network to which you connect. Employees accessing or disclosing personal information outside the requirements or authorization of their employment. And two examples come to mind, of course, both infamous or famous, depending on your point of view. Edward Snowden and Chelsea Manning, two US personalities, both of whom did exactly what this bullet point is all about. Paper records stolen from insecure recycling or garbage bins. We've seen many instances of that here in Australia. Hospital records thrown away in rubbish bins and then left outside hospitals for all to see. Very poor record handling and record keeping protocols. And we've even had an example of a law firm, client files thrown away in a similar fashion and then being picked up in the street and finishing up being dealt with in the media. Not only incredibly embarrassing, but destructive of the particular client's or patient's personal information. Agencies or organisations mistakenly providing personal information to the wrong person. We've seen that in the medical field and other fields where sensitive personal information is given to the wrong person, usually human errors, not much by the way of malicious or criminal activity there, but it does happen and it is a data breach. And then, of course, the individual masquerading, usually online, as someone they're not, and thereby deceiving an agency or organisation into improperly releasing the personal information of another person. So what are some examples of data breaches? We talk about them more in the terms of major cyber attacks rather than data breaches, but they are essentially the same thing. So I'm leading off with some examples from the education sector. And the first up there is a Western Australian TAFE. 13,000 student records were compromised. The source of that comes from the BDO Cybersecurity Report of 2017. It doesn't actually, unfortunately, detail what happened with those records, but I can imagine it'll be mostly identity theft and perhaps an effort to extract money from either students or their parents by nefarious means. Then we have in recent times also 2 Victorian schools whose online management systems were hacked. One of the hackers used information to send hoax emails to parents requesting their bank account details. And as you would perhaps anticipate, a number of parents did in fact send that information, believing the email to be legitimate. The breach also resulted in the publication of personal information of certain families, names, addresses, telephone numbers, and the like. Now, with the Tasmanian school, I just want to read for you a report from 19th of May 2017, which was published by ABC News, which dealt with this particular data breach. It's a short piece, so I'll read it to you. And it's like this. At first glance, the email from the chairman of the school board to accounts payable did not seem too odd. While the chairman's email address was not familiar to Launceston Church Grammar School accountant Jason King, it had the aura of authenticity. Even the request to transfer money to a Hong Kong business was not that unusual. The school deals with suppliers there. What stood out was the amount, $121,000, well outside the $2,000 to $5,000 range Mr. King was used to dealing with. After a brief call to the chairman, who must have said to him, and I'm interpolating here, must have said to him, "This isn't from me," Mr. King sued the Australian Federal Police and Australian Competition and Consumer Commission onto the case. Mr. King said, "I got another email from Hong Kong that day asking how the payment was going. I told them, really well, I've left it in the hands of the police. And that was the last I heard from them," Mr. King said. Not every business is as alert. So that's an excellent example of the use of the fake email scenario. Now, before I leave the education sector incidences, I also wanted to read to you from a newsletter from the Business Higher Education Roundtable, published in December 2016, which also gives you an idea of the vulnerability of schools and universities. The newsletter says the following. Recently, the University of Calgary in Canada received international press coverage regarding a ransomware attack. The attack crippled many of its key systems and tied up a large number of IT technical staff for well over a week. Systems impacted included authentication systems, logging onto systems was impacted, and access to email, research data, and network drives was blocked. After a significant unsuccessful effort to decrypt the infections, the university agreed to pay the $20,000 ransomware in Bitcoin. Earlier this year, the Janet network in the UK, which provides the internet feed to UK-based universities, schools and government, was subjected to a cyber attack type known as a distributed denial of service, the acronym being DDoS. This type of attack sends a very large amount of internet traffic to institutions so that they are blocked from receiving or sending information and hence are effectively taken offline. This particular attack lasted for several days and significantly impacted universities. Similarly, the Massachusetts Institute of Technology, shorthand MIT, in the USA has incurred at least 35 sustained DDoS attacks this year alone. California's Berkeley University incurred 2 major breaches recently, one exposing the login details and education and private information of up to 80,000 students, alumni and staff. Pennsylvania State University were required to take all of their engineering department servers offline, following advice from the FBI. The Chinese hackers were sifting through their servers. In this case, the engineering department were developing sensitive research technology for the US Navy. Australian incidents are kept more under wraps. However, there have been multiple instances of website defacements, Facebook hacks, data breaches, account credentials leakage, server compromises, ransomware, successful phishing attacks, malware infections, and other incidents directly against Australian universities. So some further data breaches, and these may be familiar to some or even all of you. A few years ago, we had worldwide attacks using malware and ransomware that was called Petya and then NotPetya, and the WannaCry ransomware attack. Amazing attacks because, as I said, they were worldwide and not isolated to either a few companies or in particular countries. Then we had, again, a few years back now, the massive data breach that affected Equifax, a major American credit agency. 143 million client records were compromised there, principally social security numbers, which of course we don't have, but very similar to Medicare type information. Then the Paradise and Panama Papers, the leak of financial records, of many individuals and their corporate structures. Again, you may say in this instance that's a good thing because people are either minimizing or avoiding tax, but nonetheless it is a data breach. SWIFT is the platform which is used to transfer money from one country to another. And so the attack here was an attack on the global banking system. It occurred in India. No money was actually taken by the hackers, but they created false trading documents using this system. And that could, of course, have resulted in financial loss to the parties who were faked, as it were, in the trading documents itself. But as I said, no money was taken in this case. John Karlbetzer, you may know, is a wealthy Australian businessman, and he lost $1 million in what's called a Beck scam, business email compromise. And business email compromise is what the attack at the Launceston Church Grammar School was as well, if you have a think about it. So it really is using business emails that look very legitimate from legitimate sources, from people you've dealt with before, and you do the click on and away we go, we have a scam. In this particular instance, someone known to Mr. Karlbetzer was looking for $1 million, and he parted with it and lost it. Facebook and Cambridge Analytica, I don't have to spend too much time on that because obviously that has been in the news for quite a while now, and the repercussions of what happened there is continuing, and I suspect will continue for quite some time. And then most recently, this has really only come to light this week, Russian state-sponsored actors have been out and about using cyber attacks on commercially available routers and switches. The Australian government, the American government, the UK governments have all put out alerts about it. The Australian government has said that no data seems to have been compromised by these attacks, but there is a fear that it was a test run to see if they could in fact gain access to these platforms to get into other platforms where the bad behaviour would actually occur. So moving away then from that background, let's have a look at what's actually been happening in the data breach notification world in Australia. So before the NDB scheme came into play, the Office of the Australian Information Commissioner, the OAIC, administered a voluntary data breach notification scheme, as well as the mandatory scheme for digital health data breaches, which is prescribed by the Commonwealth Act, My Health Records of 2012. In 2016-17, so that's the last year we have reported figures for, there was 114 voluntary and 35 mandatory health data breach reports. The general consensus there was that there was an underreporting of data breaches. And I think that's been the general view for quite some time, because if you think about all the organisations that exist in Australia, it's highly unlikely that there are only 114 data breaches within the year 2016-17. But if people are not obliged to report, then the vast majority of people are not going to do it. We've just had, however, the first quarterly report published by the OAIC, and that report reveals that in the first 6 weeks of the scheme's operation, the OAIC has already received 63 data breach notifications. Just over half of those notifications indicated the cause of the breach to be human error, with other causes being malicious or criminal attack. Of the top 5 sectors that notified a breach, private education made up 10%, Now that's a fairly high number, perhaps a bit higher than I would have expected. Mind you, 10% only equates to 6 notifications, but it's still 10%. So again, it really does emphasise the point that the education sector is not immune to data attack. And then finally, what I suppose is a good statistic at this point in time is that most of the breaches affected less than 1,000 people. And a good 90% affected a lot less than that. But as we proceed with the scheme's operation, I suspect we will see more and more reports and bigger numbers than we're looking at here. Remembering that the OAIC has launched an investigation into the Facebook Cambridge Analytica matter, and depending on what the report shows, the outcome might dramatically lift the numbers in the scheme's operation. So, education sector, how does it get caught into the NDB scheme? So the scheme will apply to private schools and private universities in a number of ways. First, where their annual turnover is more than $3 million. If they're providing health services, if they're providing credit, and that doesn't necessarily mean lending of money, but it may be time to make payments of fees or other expenses that parents, students have to pay. The minute you go, I think it is outside of 7 days for payment, you're caught with provision of credit. And lastly, if any of your institutions are holding tax file number information. The NDB scheme doesn't apply to state or territory schools or public universities. They are covered by other legislation that apply in their state or territory. In Victoria, for Victorian public institutions, they're covered by the Privacy and Data Protection Act, and for health information, the Health Records Act. I say for the most part, simply because if any of these institutions hold tax file number information, then to that extent, they are covered by the NDB scheme. So moving then finally into the Privacy Act and the NDB scheme that is part of the Privacy Act. And we're going to just look at it and analyse some of the legislative provisions. But to start with, there are two key definitions, and I've put them up on the screen. The first one is personal information. It is defined as information or an opinion about an identified individual or an individual who is reasonably identifiable. Now, we don't have any guidance as to what that means at this point in time, but that'll be interesting to watch as to how you determine whether an individual is reasonably identifiable or not from any particular record. But that's what the definition prescribes. Moving on then, whether the information or opinion is true or not, and whether the information or opinion is recorded in a material form or not. So it's a very broad definition. Health information, I haven't been able to set out the entire definition because it's quite long, and I didn't want to take up a page doing that, but just to give you an idea, it includes information or an opinion about a person's health, which is stating the obvious, but health includes illness, disability, or injury. Any health service that has been provided or to be provided to an individual, or the individual's wishes for future treatment, but provided it is also personal information. The Privacy Act has at its core 13 Australian privacy principles, and it really sets out everything you need to know about the collection, use, maintenance and disposal of personal information that an entity might collect in conducting its operations. And the two important APPs, to my mind, in the context of the NDB scheme, are APP 11 and APP 8. 11 talks about taking reasonable steps to protect personal information from misuse and unauthorised access. And at the core of 11 is that an entity should only collect the minimum amount of information that's needed for whatever function it's performing. It's really important that entities don't go about collecting tons of information that in the end turns out to be unnecessary. And it's certainly the best way to avoid difficulties is if you have a targeted collection of personal information. And 8, I mention because in this sort of globally connected world, personal information may well flow from Australia to other jurisdictions, and there are some very clear rules about what you have to do if you are disclosing personal information across borders. This is particularly relevant, I think, to schools and universities who may have campuses overseas. There are provisions for the interflow of information between overseas and here, but you really do need to be aware of what you can and can't disseminate. So, information kept by the education sector. It was interesting when I sat down to prepare this presentation, thinking about what information the education sector might hold. And I haven't been at school or university for quite a while, so it was a bit of a struggle, but I came up with this list. It's not exclusive, but it certainly gives you a broad understanding of the things you need to think about. So you've got student admission and enrolment information, you've got family financial information. That's really important in the context of if scholarships are being given or discount on fees are being given. These things can be very sensitive to the particular families and students. And so this is personal information that really needs to be guarded. Then there are attendance and behavioural management issues, health and welfare records, academic performance, including learning difficulties, student photos, and publications on social media. We've all heard enough stories about bullying online and internet trolls to know how important those matters are. You cannot not have student photos, obviously, but it's a question of how you protect them and how you guard against misuse. Then another thing that occurred to me was school boards and university boards, of course, as well. They all have meetings, they record their meetings, they make decisions. There may well be personal information contained in those records. And then there are records about external suppliers and contractors to schools and universities. So as I said, there is a vast array of potential personal information in all of these records. So what does the scheme provide? Well, the key concept is eligible data breach. And an eligible data breach occurs where there is an unauthorised access to or unauthorised disclosure of personal information that a reasonable person would conclude is likely to result in serious harm to any of the individuals to whom the information relates, or the personal information is lost in circumstances where the unauthorised access to or unauthorised disclosure of the personal information is likely to occur, and assuming it were to occur, a reasonable person would conclude that it is likely to result in serious harm to any of the individuals to whom the information relates. Now, I appreciate that is a big mouthful. but that's what the legislation provides. And it really does boil down just to a few concepts, really, if you think about it once you read it a few times. So the reasonable person test and the likely risk of serious harm test, which I highlighted in italics, they are to be treated as what we lawyers call objective tests, as opposed to being subjective tests. An objective test is really when you've got the third-party bystander looking at a scenario and then making a determination about it because they have no skin in the game, where, of course, a subjective test is the individual affected making a decision about something, and of course there's a lack of objectivity there. And in considering these two tests, the explanatory memorandum to the bill, which became the Act, says that we should interpret these standards in accordance with commonly understood legal standards of objectivity and probability, which is something I've just gone through in a slightly different way. The scheme doesn't define harm or serious harm, and I can understand why, because there can be many forms of harm, and the legislature probably didn't want to lock in the definition so that it could be accommodated by circumstances or as time goes by and we understand better what harm or serious harm might mean in the context of a data breach. But having said that, the scheme does give us some idea as to how we should determine whether serious harm has flowed from a data breach. And in doing so, we need to have consideration to a number of things, including the kind of information at hand, how sensitive it was, whether the information was protected by security measures, and if it was, the likelihood that such measures could be overcome. So it's really then analysing, well, did you have really good firewalls? Did you have really good data protection? And if it was a bit flimsy, then serious harm is more likely to have flowed than if you had really good security. The persons or kinds of persons who have or could obtain access to the information, including whether they have obtained or could obtain information on knowledge required to circumvent the security measures. So your student prankster is going to be looked at in different light to your Russian state-sponsored hacker. Then, of course, the nature of the harm and what lawyers love to say best, any other relevant matters. Now, we do get some guidance about serious harm, not from the legislation itself, but from the explanatory memorandum to the bill. And it says that it could include serious physical, psychological, emotional, economic and financial harm, as well as serious harm to reputation. So it's a very broad brush approach and gives us a much better idea of what we should treat as serious harm. It's not just the physical, it's not just the emotional, but it's this whole panoply of harms that you see on the screen. Suspected eligible data breach. It's another important concept. And it goes like this, that if you have a suspicion that there has been an eligible data breach, then you've got to act promptly. You've got to carry out an assessment, and you've got to determine whether there has in fact been a breach, which would be an eligible data breach. And the Act says that you've got to complete your assessment within 30 days of becoming aware of the relevant circumstance. Now, you can't just do a perfunctory testing of whether there's been a breach. It's got to be reasonable and expeditious. It can't be half-hearted. If you do a half-hearted check or the she'll be right mate approach, then you won't have complied and there might be consequences down the line for you if you adopt that approach. Remedial action is important here in this context of the suspected data breach. So if you think that there has been a breach, or that there might be a breach that is going to result in serious harm, then you have an opportunity to remediate the problem. So I cite as an example, if somebody leaves their laptop in the back of a taxi, and after you've rung the taxi company, it can't be found. If your IT team is in a position to then wipe everything that's on the laptop, and good security systems will enable you to do that, then that would be considered to be remedial action, and that there's no problem thereafter, and this will not then rise to the level of an eligible data breach, and it won't need to be dealt with. However, if you have reasonable grounds to believe that there has been an eligible data breach, it's one that you just simply can't fix, then there are a number of things the legislation says you have to do. The first thing you have to do is give a statement to the Information Commissioner, and the form of statement actually can be found on their website. Of course, you're not bound to use that form as long as you follow what the Act provides, but it's very convenient to use the form that the OAIC has prepared. And the statement will require you to give the following information: the identity and contact details of your school or your university, a description of the eligible data breach, the kind or kinds of information concerned, and your recommendation about the steps individuals could take in response to the eligible data breach. Now, that may be a very difficult step to take, because there may be different things that different individuals could do, and they may not, of course, all be known to you, but you have to try and make those recommendations as the Act requires you to do so. You also then have to take reasonable steps to notify the contents of your statement to affected or at-risk individuals. And where this isn't practicable, the statement must be published on your website if you have one. And if you don't have one, then you've got to take reasonable steps to publicise the contents of the statement. And no doubt the best way to do that would be in a national circulating newspaper, unless you want to take out an ad on media, and I suspect nobody will want to do that. These steps have to be taken as soon as practicable after completion of the statement to the Commissioner. And of course, we all appreciate that in the context of schools and universities, there may be a number of affected individuals, and it may be a difficult thing to be sending out thousands of statements, but that's what the Act requires, and it will have to be done. There are a number of exceptions, however, to the notification requirements. Most of these, I suspect, will never apply to the education sector, but I'm putting them in just so that you're aware of them. Notification doesn't have to be given if it would be contrary to a secrecy provision in other legislation. The Commissioner declares that notification is not required, but his powers to make such declarations are limited, but I haven't set them out for you. Where there is more than one entity affected by the eligible data breach, only one of the entities needs to provide the notification. That may well be useful and apply to schools and universities if they are in fact set up with one or more corporate entities or other forms of entities that run the school and the university. If there's a breach in one of those entities and it spreads across other entities, then only one entity needs to report. And then, of course, if you're obliged to notify under My Health Records Act, because there's a health data breach, then you don't have to do it under this Act as well. Now we come to the pointy end, and that is enforcement. So the Australian Information Commissioner has a range of enforcement powers given to him by the Act. He can commence investigations in response to a complaint or do so on his own initiative. The Facebook investigation is an example of the Commissioner acting on his own initiative. He can accept an enforceable undertaking and bring proceedings to enforce it. Enforceable undertakings are a form of agreement between the offending party and the Commissioner, whereby the offending party acknowledges the data breach and the misbehaviour that they've been involved in, and promise not to do it again, and on pain of further proceedings to enforce it. Often you can find also that there will be steps imposed on the offender to ensure that they in fact don't breach the laws again, including getting external consultants to review their processes and things of that sort. The Commissioner can make a determination and bring proceedings to enforce that. He can apply to the courts for what's called a civil penalty order for a breach of a civil penalty provision. Now, the Act actually specifies what sections are considered to be civil penalty provisions. It's beyond the scope of today for me to go and set all of that out and talk to you more about civil penalty orders, but they are linked to the civil penalty provisions. Where there's serious or repeated interference with the privacy of an individual, the courts can issue the civil penalty on the application of the Commissioner. And just to give you an idea about what the maximum penalties are, at the moment for individuals and other forms of non-corporation, $420,000, and for corporations, $2.1 million. Now, these are low fines, admittedly, when you're talking about breaches committed by, say, a Facebook. It really is pocket change to them. I suspect these penalties will go up in time, but in the scheme of things, they are reasonably serious, and when compared to fines for other breaches in other legislation, and that's where we are at the moment. In terms of resources for you to go and have a look at, the OAIC has extensive information on its website. It's relatively easy to navigate, and you should look for the principal guide that it has published. I've given you the title of it. It's wonderful bedtime reading if you want to be across this topic, but it is, as I say, very helpful. So I want to nearly finish up with just having a chat to you about a new scheme that is about to commence in Europe. The European Union General Data Protection Regulation starts on the 25th of May. I'm highlighting this only because it is covering such a large geographical area of the world, but it is not the only form of privacy regulation that is worthy of note. There are many jurisdictions in the world that have privacy regulation and data reporting. And of course, if you are a school or an education, a tertiary education institution, then you need to know about the data protection regimes in those particular countries if you are operating in those countries. The GDPR has similar concepts to the Privacy Act, but it is more stringent in what it requires. It captures, of course, all EU entities, but it also captures non-EU entities, regardless of size, where the data processing activities are related to two things: offering goods or services to individuals in the EU, and interestingly, whether they are free or not, and monitoring the behaviour of EU individuals where the behaviour occurs in the EU. Now, the GDPR talks about data controllers and data processors, whereas we just talk about the holders of personal information. Data controllers are those people who are the holders of personal information, and the data processors are those persons who actually use the data for various reasons, whatever they may be. The GDPR talks about personal data, whereas we refer to personal information. And the next bullet point is a stark difference between our Privacy Act and the GDPR. So if there is a mandatory data breach, if there is a data breach, it's mandatory that it be reported within 72 hours, unless the breach is unlikely to result in a high risk to the rights and freedoms of individuals. And of course, there are exceptions to notification similar to the exceptions that I spoke to you about our Act earlier. So very different test, and it expresses a greater urgency of reporting than our Act does at the moment. The GDPR also grants specific individual rights. So the right to erasure, which is the right to be forgotten. You may have heard about that in the context of cases brought in Europe by individuals seeking to have Google remove information from their data sets. They have the right to data portability, so you can take your data anywhere to any entity and it's not stuck in the one place. And you have the right to object to your personal information being kept or in fact logged by anyone. We don't have any of those rights at this moment. Overseas transfers of personal data, similar to our APP8, is permitted in limited circumstances. Again, really important for you to be aware of those limitations. If you are in fact transacting personal information across borders into Europe from Australia, entities have to appoint a data protection officer. So it's a formal obligation. We don't have to do that here as a formality, but many institutions have what's called a privacy champion, and we certainly do have privacy champions at BDO. And then the big sting in the tail, fines of up to 20 million euros or 4% of annual worldwide turnover, whichever is the higher, can be imposed for data breaches. So you can imagine if there is an egregious data breach, similar to what's happened here with Facebook, the fine can be quite massive compared to the 2.1 million Australian dollars that our Privacy Act would impose. So to conclude, I just thought I'd put in a couple of practical tips and questions for you to think about. Do you know where your data is stored? That really is a consideration of where are my servers? Am I in the cloud? Are they kept onshore or offshore? Just knowing where the data is really important. Then do you have data backup facilities? And these may sound, by the way, very basic questions, but and I accept that they are, but not everybody thinks about them in the conscious manner that I think you need to in today's era, where data is king and stealing it is perhaps queen. Do you have a business continuity plan? What happens if you do have an attack? What happens if your servers are damaged? What happens if there's an electricity outage and you can't operate your computer systems, your networks? You've got to have a business continuity plan in place. Do you have data security policies? Are they applied? Are they enforced? Do you have an independent third party testing your data security systems, using penetration testing, sending of fake emails to see what staff do with them? Do you train them about that? Very important stuff. Do you have adequate contractual protections in your third party supplier agreements? So if you are getting, as we all inevitably do, services and goods from third parties that are relevant to the data that you have or your networks, what happens if something goes wrong? Are you contractually protected if the error or the negligence comes from that third-party supplier? Are your employees trained in data security and tested for compliance? It's really important these days that all employees understand the importance of data security and understand what complying with your plans means. Do you have an incident management team and a plan to deal with a data breach? It is really too late to form it if and when you suffer a data breach and the information is out there in the media and you're being criticised and highlighted for it. You've got to have an advance and you've got to know what you're going to do if you have a data breach. So you might have someone from IT, you might have someone from legal, whether it's internal or external lawyers, you might have your media personnel, and obviously someone from management as well, as a core group. And then depending on your circumstances, you might have others in the team as well. Have you thought about cyber insurance? Do you have it? Cyber insurance is a maturing insurance market, and so it's very, very important that if you are going to take it out and look at it, that you try and get a really good broker who understands the industry, where it's going, and that you carefully examine the terms of the cyber insurance and know what it provides and what it will and won't cover. And then finally, have a list of do's and don'ts. If there's anything not covered in the bullet points that I said, if there's something else, put another list in. And that, ladies and gentlemen, boys and girls, is the end of today's session. Thank you very much for your attendance. If you have any questions, please feel free to either send me an email or telephone me. I'd only be too happy to assist you. Once again, thank you very much for attending, and we'll see you next time. Thanks.